So there are 6 disqualifications. So there are 6 disqualifications which the Parliament has prescribed. They are to be found in sections 8, 8A, 9, 9A, 10 and 10A of the Representation of the People Act 1951. They are common both for Parliament and for state legislatures. So if any question arises, you have to just look at those, whether he is a parliamentary candidate or he is a assembly candidate, you have to see. Now we come to the first disqualification, inviting disqualification and conviction. That is specified. If somebody has been convicted, you have to immediately look into section 8, because every conviction does not attract disqualification. In section 8, there are 3 types of convictions which are mentioned. In the first section itself, there are certain sections specified. If anybody is convicted under those 10 or 12 offences are specified. If a person is convicted for any of those offences, even if he has been fined ₹1 only, or maybe sentenced only till the rising of the court for a few hours, he immediately becomes disqualified, at least for 6 years. Sentence plus 6 years. That is section 1. Then subsection 2 says certain offences particularly pertaining to hoarding, etc. There the disqualification is attracted only if he has been convicted and for 6 months the minimum punishment. If a person has been convicted but he has not been sentenced to imprisonment for 6 months, he does not attract disqualification. Then section 3 is the general one. Whatever is not specified in 1 and 2. If a person has been convicted and sentenced to imprisonment for 2 years or more, then he becomes disqualified without reference to any offence. Any offence for which conviction has resulted in the sentence of imprisonment for 2 years or more, that immediately attracts disqualification. And the period for all this is the sentence plus 6 more years. Supposing a person has been convicted and sentenced say for 2 years or 3 years, then the disqualification will run for 9 years. So if a person has been convicted and sentenced to 2 years, so it will be 6 years plus 2 years. And if for 5 years, then it will be 5 plus 6. So that is the period of disqualification. And then question is, what is the meaning of conviction? Previously there used to be some confusion that conviction means ultimately by the appellate court, and then so long as the appeal is pending, a person can merely go on contesting. Now the law is clarified by the Supreme Court. The conviction means conviction by the trial court itself. The moment the trial court has convicted a particular person and given that punishment which attracts disqualification under section 8, 1, 2 or 3, then the person is disqualified. Even if a person goes in appeal and he files the appeal, and during the pendency of that appeal, the appellate court has suspended the execution of the sentence and given him or her the bail, that will not remove the disqualification. The disqualification will still be attached. But an exception to this is, which is very rare, the normal course for an appellate court is that they grant the bail and suspend the execution of the sentence. But they don't suspend the conviction itself. The Supreme Court has now clearly, in another subsequent case, in this case of particularly this, you must have seen this Navjot Singh Sidhu's case, they have suspended the conviction also. So where the conviction is also stayed and the execution of sentence is also stayed, bail is granted, then this means the high court's order or the lower court's order is no longer in force in any respect. So in that case only he can contest the election. But otherwise only if the bail is granted and the conviction is not stayed, the disqualification will be attracted from the date of trial court's order. Then there is just one exception. 8 says Then section 8A is not very difficult, because the election commission has to fix the period of disqualification. We circulate on the eve of every election, we circulate the list of persons who are disqualified under section 8A. So this list is nil at today. So next is person section dismissal, that I have told you already. Dismissal only for two reasons: disloyalty or corruption. And if a person says I am not dismissed for corruption or disloyalty, for your purpose he is disqualified unless he produces a certificate from the election commission and produces that certificate with the nomination paper. Then next is contract. This is of course slightly tricky. Contract, particularly it should be subsisting contract, and subsisting contract means contract which is subsisting on the date of scrutiny of nominations. Previously a person may be a contractor, but on the date of scrutiny he may not be a contractor. And then Supreme Court has also said in some cases that the contract can be terminated even unilaterally also. A person may be a PWD contractor, but he may go to the engineer or whosoever was the in charge. He may say, I am just terminating my contract, I will not do this job, remaining job. You can impose any penalty on me, you can have this work, remaining work done through any agency, I will be responsible for that, but I am not the contract holder. So on the date of the scrutiny you have to see whether the contract is subsisting. Then contract should be only for two things, not every contract. Only either he is supplying some goods to the government, he is maybe he is undertaking some ration card, some ration supplies are being made by the government. He has taken the ration shop. He is not supplying any goods to the government. He is only doing some service for the government, which is not a disqualification. So first is supply of goods, and then execution of works. Works the Supreme Court has defined as some construction work, not merely say this license or something else. So only where roads, buildings, dams, wherever the PWD is doing some job, that is, they say, that has to be given that meaning. So it's a execution of works or the supply of goods. And but another catch here, it should be with the appropriate government. Appropriate government is defined in section 7 itself. Appropriate government means if you are contesting election to the Lok Sabha, then appropriate government means central government. You may be having a contract with, say, Tamil Nadu government for supply of goods, and you are contesting election to the Lok Sabha, then it's not a disqualification. But for legislative assembly, it's a disqualification. Similarly, for legislative assembly, you are contesting. You have a contract with, say, Defence Ministry of the Government of India for supply of some goods. That is not a disqualification for legislative assembly's election. So appropriate government also has to be seen. Then of course I told you about this disqualification for government company. Firstly, we have said that the disqualifications in the government companies, director may be disqualified who has been appointed by the government, but not the other officers. But in the government company also, the law says only 3 posts. If you are appointed to 3 posts, maybe by the board of directors or by the own governing body, one is the manager, another is the managing agent, and the third is the secretary. If you are holding any of these 3 posts, then whosoever has made the appointment in that company, you are disqualified. So this, but here also the appropriate government, if you are contesting election to the state legislative assembly, that government company should be a state government company in which they have at least 25% share. But if you are contesting election to the Lok Sabha and you are a manager of a state government company, then you are not disqualified. Similarly, if you are a manager of a Government of India undertaking and you are contesting election to the state legislative assembly, that is not disqualified. Only for Lok Sabha is a disqualification, not for the assembly. So these are the fine distinction points. Then next, loss disqualification is not very complicated, because whosoever has not given the account of election expenses, the election commission takes care of those things. We issue a notice, then ultimately we disqualify some persons, and then we circulate a complete list of all those who are disqualified on a particular date. So you have to just see that list, but sometimes we have to be very careful about that list, because a person may be disqualified from some other constituency for the last election. Now he may be contesting election from some other constituency. So you have to be slightly careful. You have to just see whether this man, his name is not there in the list of contesting and this disqualified person.